Peterson. I am the chapter president of the Federalist Society here at Liberty University School of Law. The Federalist Society is a group of conservative and libertarians that are interested in the current state of the legal orders and believes that the state is to exist to preserve freedom. They believe in the separation of government powers essential to our Constitution, and that the duty of the judiciary is to say what the law is, not what it should be. And so the Federalist Society seeks to promote and apply these principles. Today we have the privilege of hearing Mr. Blackman speak today. He is an associate professor of law at the South Texas College of Law in Houston, specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He has authored 3 books, including Unprecedented, The Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty.
And the new one.
Execution Power, and the 100 Supreme Court Cases You Should Know.
It comes out on Friday. 100 Supreme Court Cases Everyone Should Know with Randy Barnett. Buy a copy. It'll help you in common law, I promise. You'll love it.
And he's has authored over 4 dozen law review articles and has appeared in New York Times, Wall Street Journal, USA Today, and a number of other national publications. He's also the adjunct scholar at the Cato Institute, the founder of the president of Harlan Institute, and the founder of Fantasy SCOTUS, which is the internet's premier Supreme Court fantasy league.
You should all play.
Yes, and you can follow Mr. Blackman, joshblackman.com on his blog, or on his Twitter at @JoshMBlackman. So help me welcome Mr. Blackman.
Thank you so much. It's a pleasure to be here. This is my first time at Liberty. I've never been here before. My last time in this area was in Roanoke 10 years ago. Why was it in Roanoke? The bar. I took the Virginia bar, and I went to George Mason for law school. And as I was driving, I said, oh my God, the Virginia Roanoke Civic Center. And that's where you take the bar. It's an awful place. It's very dark, and it looks worse 10 years ago than it did today, but it's very dark and cement and old-fashioned. But you will pass, and you will all become lawyers. But I'm not here today to talk about the bar. You can worry about that in some time. My purpose today is to talk about a topic I know quite well. 3D printed guns. Since 2015, I've been one of the attorneys litigating the 3D printed gun case. I'm not just an academic here, I'm actually a practicing lawyer, go figure, right? And I've been arguing in court for some years now that 3D printed guns, and specifically the files used to make them, are protected by both the First and the Second Amendment. And my goal today is to walk you through why I think that's the case. Let's start off with simple, basic stuff. Has anyone here ever used a 3D printer? Oh, good. What have you guys made?
A lot of instruments.
Instruments? What kind of instruments?
Like an ocarina, a ukulele.
Oh, like musical instruments.
Mm-hmm.
Ah, how about you?
Like figurines and figures.
Really? Anyone else? Okay. Yes?
Yeah, we got one at my undergrad when I was working in the library, and so we were like people to test out the 3D printer.
You had fun with it?
It was pretty fun.
Okay. 3D printers are simple devices that do cool things. You can design an object on the screen, whether an ocarina, a ukulele, a figurine, a car, a house, and you design how big it is, how long it is, how wide it is, the thickness, and then the 3D printer can transform your creativity into a real-life object. Let's start with a basic tutorial of how 3D printing works. And this is some very simple code. If you know nothing about code, that's quite all right. Let's say I want to make a cylinder, right? A tube. If I tell you that I want a cylinder with a height of 20 inches and a radius, a width of 5 inches, you know what that looks like, right? It's about 20 by 5. That's it. I can use very simple, straightforward words to convey what an object in 3 dimensions will look like. The magic, though, of 3D printing is it transforms this computer blueprint into a real-life object. So here are some trinkets and maybe figurines, little chess pieces maybe, right? But you can make things that are more sophisticated. This printer is designing a race car, which is pretty elaborate. You can also print parts of human anatomy. This is basically a replica of a human brain, right? Now, how does a 3D printer work? It functions very similar to making a candle. Has everyone made a candle before, right? How do you make a candle? You take the wick, you dip in the wax, you pull it out, let it cool. You dip in the wax, you pull it out, you dip in the wax, pull it out. You keep dipping it. And every time you dip it, it gets a little thicker around the base. 3D printing works in the exact same fashion. But instead of dipping into wax, you're spraying a very thin layer of plastic, one on top of the other, on top of the other. This diagram illustrates it. You have a nozzle, and it's spraying very thin layers of blue plastic on this bed. And it's making a ball. So it starts off the bottom, a little bit thicker, a little bit thicker, a little bit thicker, then it gets thinner, thinner, thinner. You can make a fully functional ball. This photo shows it from a different angle. Here you have a heated bed, so it gets a little hot. But you're basically spraying, and the little nozzle moves around to design the intricate design. Make sense? OK. I want to show you now a demonstration. I want to show you now a demonstration of printing an actual object. But you have to guess what object's being printed. OK, so you have a little challenge. Let's see how quickly you can do it. All right. So first off, this is number one. You print off this base, which is like a honeycomb lattice, right, in the shape of hexagons. That's number one. Number two, put a little bit thicker. OK. Number three, a little bit thicker. Number four, a little bit more. 5. Anyone want to take a guess yet? Not yet. OK. 6. Frog, you're in the ballpark. You're on the right track. 7. Anyone see it yet? Come on, Liberty. Don't disappoint me. No, I wish it was James Madison, but it's not James Madison. That would be nice. Is it? OK, you're on the right track. 8. 9. Oh, come on. Come on. Now you should get it. 10. Oh, is he banned on campus, maybe? Maybe this movie's not allowed? Yeah?
It's a bust of someone?
Yes, it's a bust. Of who? 11. Oh my God! I thought maybe he was banned, sci-fi. I don't know, the work of Christ, satanic worship. I don't know. What am I doing here anyway? Is you're allowed to watch Star Wars in Liberty? Is that okay? There it is. Okay. I don't know. The Force is not strong with this one. Okay. There it is. Okay, now everyone sees it. Yoda from Star Wars. Okay. Keeps going. Okay. The ears look great. And then you come to the top, and then you close off the dome, right? Now, that probably took 20 or 30 minutes to print. I am not artistic. If you gave me a block of clay, I could not shape that. If you gave me a block of wood, I could not chisel that. If you gave me a thing of stone, God, I could not knock that out, right? But if I gave you all a 3D printer, you could all make that in a fairly short period of time. That is the promise of 3D printing. It allows you to take your creativity to design objects on a screen and then bring them into reality. We can make some pretty sophisticated, intricate designs using a 3D printer. But I'm not here to talk about Yoda, right? I didn't travel 2 flights and an hour drive to talk about Star Wars figurines, right? Why am I here? What do people want to 3D print? Not Yoda, guns, right? almost immediately after people recognized that you can 3D print stuff that's pretty good, attention turned to making firearms. Specifically, the Liberator. The Liberator was the first fully functional firearm that could be printed on a 3D printer. This is the design for the barrel of the Liberator. Right now, a barrel, if you think about it, is just a cylinder. Right? It's a tube. I showed you earlier how to make a cylinder. I played a trick on you. That's precisely how you can make a fully functional barrel for a gun. Since 2015, I've represented a firm called Defense Distributed, based in Austin, Texas. They made international headlines. And they made headlines for developing a number of 3D printed firearm parts. What's this? This is, I'm Virginia, what is this? Thank you. Some schools, they don't know what this is, so I have to remember where I am. This is an AR-15 lower receiver. This is the guts of a gun. This is what makes a gun work, right? Generally, if you buy one of these in a store, you have to go through various background checks. If you make your own, you don't. So there's generally an exception to most gun laws if you make it yourself. You can't sell it. Don't sell it. But if you make it yourself, it's fine. Here you can manufacture a lower receiver for an AR-15. They also were able to manufacture a magazine. That is the place where you put bullets in. But what put Defense Distributed on the map globally was this. Josh, what the hell is this, right? This is, what the heck, I have to remember where I am, sorry. I have to just modulate a little bit. What the heck is this, right? This is, these are the parts for the Liberator, right? These are the parts for the Liberator. Each component can be printed at home. The blue thing is the handle. This big white thing is the receiver. This little round thing over here is the barrel, the cylinder I showed you. It's where the bullet comes out of. These little squiggly things, these are the springs. When you pull back the trigger, it then strikes. The only metal parts are twofold. The bullets are made of metal. You can have a plastic bullet. They don't work very well, but you can have a plastic bullet. I guess depending on what you're trying to do. They might do something else. They don't work well for intended purposes, right? And a nail, a common nail. What's the nail used for? It's the firing pin. What's a firing pin? It's the thing that hits the back of the bullet, which makes it go boom, right? So the entirety of the gun is plastic with the exception of the bullet itself and the nail, which is used for a firing pin. This is what it looks like when it's fully assembled. It's pretty ugly. It's not very effective. It's not very accurate. It's also not very safe. Metal, steel, right? Steel is a very good material to make a gun out of. Why? When steel gets hot, it expands. When steel cools down, it contracts, right? Good for a gun. Guns get very hot when you shoot them, and then when they cool down, they sort of get back to normal. Plastic is a terrible way of making a gun. Why? What happens when plastic gets hot? It melts. What happens when plastic gets cold? It cracks, right? The very nature of having a gun made of plastic means you're going to have trouble firing it. And if you don't make it right, it will blow up in your hand, and you probably lose a finger, right? This is a terrible gun. Now, if you see this picture here, there's a little rope on the floor. See that rope? Why is there a rope there? Because when they were testing it initially, they didn't want to pull the trigger because they blow off their hand. So they would put a rope on the trigger and stand very far away, and they would pull it from a distance. Okay? You can't just print this thing. You also have to put in an acetone vinegar bath, this sort of chemical treatment, to make sure the plastic is strong enough to withstand the combustion. Okay? Also, it's not accurate. There's no rifling. That is, the barrel doesn't have the grooves in it that make the gun accurate, right? When you just fire a gun without any rifling, the bullet flies wherever. You can't really aim it. This is a terrible way of making a gun. It might take over a week to manufacture all the parts. I'm not joking, like maybe 40 hours of labor to make this. It's very expensive too, and it's not accurate. If anyone wants to buy a gun, this is the last place in the world they will go to get it. This is just not how you would try and get an illegal gun. But it exists. In 2014, the Liberator was released, and it made international headlines. Now, is there a problem? Is there a problem with printing these guns for your own use? If you sell them, you're in trouble, but just printing for your own use, right? Is that a problem? First off, when I say 3D printed guns, this is generally what people think of, right? Where you just click print and a gun pops out. No, 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 no. Again, it can take about 40 hours of labor to print this thing. It's probably going to blow up in your hand, and it's not very accurate. It fires one bullet and it overheats, right? You might get one shot and the gun's toast. Most people simply don't know what it actually takes to print a gun, which is why I spent so much time during this presentation explaining the actual process of creating this type of weapon. Hi, welcome. There are a lot easier ways of making a gun. Have some of you heard of a zip gun, right? Know what this is? A zip gun is a homemade gun, right? It's a gun you can make at home using materials you find at the hardware store. I found this design on the internet. God bless the internet, right? You can find everything on the internet. This is a gun. What is it made out of? A soldering iron and a garden hose. That's it. I can go to Home Depot and buy $10 worth of parts and make a gun. I don't need a $50,000 3D printer, right? You take a garden hose, the little nozzle on the tip of it, and a soldering iron, and you fashion them together. And you made a gun that is a lot stronger than anything I can 3D print, right? It's better. These ones actually scare me. I found these on the internet also. Thank you for the internet. This is a keychain flashlight, right? Someone actually hollowed out, you know those keychain flashlights? They hollowed out the middle, and they made a fully functional firearm. So when you hit the button on the back, you're actually striking the bullet. What was that? Yeah. Do yourself, don't Google zip guns, right? Just it's probably a bad idea, but like people get really creative and they make like really dangerous stuff that is not hard to make. Now, I want to show you something. I want to show you a demonstration. But please do not try this at home. Don't worry. I have no props. It's all on the screen. But do not try this at home, my friends, okay? These guys in a garage somewhere are going to make a rifle out of a rubber tube and a metal pipe. $5 worth of parts. And you can see they have a flip phone camera, so this is legit, right? This is like, this is serious business here, right? Please don't try this at home. So what are these guys going to do? They're going to use the back of the barrel, the back of this pipe, as a firing pin. And they're going to wedge the shotgun shell, the red shotgun shell, into this rubber tube. Okay? Everyone knows where this is going, right? People are shaking their heads, yeah. So they're gonna jam. They're gonna jam the pipe into the back of this rubber tube. Now, I want to just take a step back and do a little safety check. What's wrong with this picture? Everything, yeah, everything, right? But in particular, what's wrong with this picture? Okay, so number one, his hand is in front of the barrel. Okay, don't put your hand in front of the barrel of a gun, okay? But there's something else really wrong with this picture. I mean, putting aside the barrel thing. Okay, they're inside. You should not be shooting inside. Good rule. What about, where are they? What's sort of like in the background that might be problematic? Anyone see it? Let me show you the next picture. It's a little more obvious. There is an electrical outlet right there, plugged into this fan. So they're basically firing into a live outlet. And this box, this is their firing range, has a bunch of holes on it. So they've done this before. All right, but why am I showing you this? I'm trying to demonstrate a point. It's really easy to make a gun. And it's really easy for not very smart people to make guns and do dumb things with them, right? You don't need a $50,000 3D printer and 40 hours of labor and intricate coding to make a gun. You can go to Home Depot and spend $10 and make a firearm. By the way, a rubber tube would not be detected in a metal detector. It'll go right through any detector. You could use a plastic pipe just the same. It would work just as well for the firing pin. All right, so ready? We're going to fire this. He's going to jam it. Ready? Ready? 1, 2, boom. Lethal weapon. Right? Yeah, I see. Oh, you're like, oh my God. Like, it's just the looks in your face, like this guy. Right. They just made a rifle, and they fired it, and they actually survived. And here they are. They took the shell out. It's smoking. It's so cool, right? This video is actually on YouTube. I can't play it. The language is very bad. I think they would throw me off campus if I play this video, right? But just you can Google it, you can find it, but it's a little rough on the ears. But that's it. They made a gun, fully functional, lethal weapon. Now, did these guys break the law, right? Did they actually do anything illegal? I'll presume they're not in California because the answer is different there. But in almost every other state, what they did is perfectly lawful. New Jersey too. Now, New Jersey's in the club also, right? According to federal law, the Bureau of Alcohol, Tobacco, and Firearms says you can make your own gun as long as you don't sell it. There are exceptions. You can't have what are called short-barreled shotguns, and you can't have what are called basically automatic weapons, machine guns you might call it, right? There's certain exceptions, but generally, almost any gun you want to make at home, you can make at home. So why am I here? Right? Well, so far the government hasn't actually come after those who print these guns. States are starting to. But the federal government hasn't really been interested in people who are printing the guns. Instead, the feds have come after people who share the files. Again, they're not prosecuting people who print these guns. They're trying to punish those who put files on the internet. And that's where the First Amendment comes in. At the most basic level, the Supreme Court has said that the government can't stop you from speaking. This is what's known as a prior restraint of speech, right? The government can't stop you from engaging in certain types of communication. They might punish you after the fact for having engaged in that communication. Think of like a tort of defamation or libel, right? But they generally can't stop you in advance. Now, you might say, wait a minute, Josh, this is crazy stuff, right? These files are dangerous. People who download these files can kill people. This is not a joke, right? Well, look, nothing's new under the sun, my friends. We have long had books. Books existed before computers, right? We long had books that could be used to harm people. I assume you've heard of the Anarchist Cookbook. You know what that is? I see nodding heads, yes. These are the deviants in the room, right? The Anarchist Cookbook is basically a hand guide to be a terrorist. I'm not being too glib when I say that. It teaches you how to make bombs, how to make poisons, how to do some pretty awful stuff. And back in the 60s, where people used this book to do bad stuff, governments tried to ban it, keep it off the shelves, right? If we ban the book, then people can't get there. And the courts consistently said, no, 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 you cannot ban books. Okay, Josh, but we're not talking about a book here. We're talking about information. We're talking about code. Is code speech? Yes, my friends, it is. Whether I choose to design a picture on my piece of paper or on a canvas or on Photoshop or some other electronic means, the courts have said pretty consistently that expressing yourself using a computer is protected speech. And indeed, the court's gone beyond that. They said not only is the creation of information speech, but also the dissemination, that is the sharing of information is speech, right? It's not enough to speak to yourself. You should be able to speak to others. And that's the sort of two-way street that a First Amendment protects, right? We are surrounded by code. And by the way, the Matrix turned 20 years last year, if you want to feel old. I came out when I was in high school. I remember that movie very well. Guys probably were barely born yet, right? The thing about being a law professor is we get older and you say the same age, right? Because every year, law students are roughly 24, 25 years, give or take, right? Plus or minus a few years. We keep getting older, so the gap keeps growing. That's this profession. So our jokes and puns get dated. We have to start recycling and taking them out. But we're not here only about the First Amendment, right? We are here talking about the Second Amendment also. Because the thing which is being censored is information used to make a gun. The Second Amendment states a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Supreme Court has had two major Second Amendment cases, possibly a third this year, we'll see. The first was called D.C. v. Heller, in which the court held that the Second Amendment protects a right to bear arms in the home, not tied to militia service, and that this right limits the federal government. 2 years later, the court had a follow-up case, McDonald v. Chicago. This was Otis McDonald. He passed away a couple years ago. This case involved Chicago's handgun ban. And the court held that the Second Amendment also restricts the states by virtue of the 14th Amendment. So now we have both Heller and McDonald, these two cases saying that you have a right to keep a gun at home. But that's it. The court hasn't said much more than that. They might give us some bits this year, although I'm not optimistic now. Maybe I can talk about that in Q&A if you like. But the court has not said much. But I'm going to make two arguments I think are supported by logic, at least, if not precedent. Hello, come on in. The first is that the Second Amendment protects a right to acquire arms. What do I mean by that, a right to acquire arms? Well, imagine a world where the government says, okay, you can keep a gun if you have it, but you can't buy any new ones, right? Yeah, that's not too unrealistic, is it? Right? If you have a gun, you can keep it, but if you don't have one, too bad, you're out of luck. I think a flat-out ban on acquiring guns would be unconstitutional under Heller. There has to be some means to actually get a gun. Now, there can perhaps be regulations on the commercial conditions, people who have mental health issues, people who have criminal backgrounds. Okay, that's fine. But there's some right to actually acquire the gun within the Second Amendment. The second right is actually a little bit more solid. And I call this the right to make arms. Long before we had stores that sell guns, or maybe don't sell guns anymore, I don't know, if you wanted a gun, you had to make it. Going back to colonial times, people who wanted firearms were gunsmiths, and they made it on their own. There's a very long, deeply rooted, established right to keep and bear arms and make the gun that you're going to use. So I think that this right, in fact, is more deeply rooted than the right to actually acquire arms because people were making them before they bought them. Why is this significant? We have a case here where the First and the Second Amendment work together. And this is what's sometimes been called a hybrid right, which is sort of this elusive creature. But let me give you an example, right? Let's say the state passes a law that makes it a crime to wish someone a Merry Christmas, right? The war on Christmas, right? It's a crime to wish someone a Merry Christmas. Is that a violation of free speech, or is that a violation of free exercise? Or is it a violation of both? Both. Or I'll give you another example that maybe people in this room may not like, but does exist, right? Bans printing books of how to perform, right? Right? The state says no more books to teach people how to perform or the 14th Amendment. So there are some cases where the free speech reinforces other rights, and this is something that Justice Scalia has written about in an opinion some 30 years ago called Employment Division versus Smith. These notion of hybrid rights. What's going on here? The government is censoring you of how to actually exercise your right to bear arms, right? They're saying you cannot share information of how to make a gun. And this is not just, people want to make plastic guns in their basement. If I'm a gunsmith, right, and I'm an Olympics target shooter, and I found a way to make a more accurate scope, or how to tweak the barrel to get a few more inches of accuracy in a long-distance shooting competition, right? I can't do that. It would be now no more books on how to gunsmith, right? No more books on how to tweak your barrel to get a little bit more accuracy in a target shooting competition, right? We say, of course not. But that's sort of what's going on here. The difference is it's not a book, it's code. All right. Now let me talk for a bit about what sort of regulations exist now. The leading law that's on the books is called the Undetectable Firearms Act. It was enacted in 1988, before most of you, I think, were born. The law requires all guns to have a certain quantity of metal in them. Enough metal that could trigger a magnetometer, an X-ray machine, right, at the airport or whatever. You can't have a plastic gun. Now, Josh, wait a minute. 1988? I thought you said the guy printed the gun in 2014. Yeah, I did. Plastic guns are not new. Undetectable guns are not new. This panic has been going on for nearly 30 years or more. In fact, this law was largely inspired by the Glock handgun, which is a very good gun. There was one line in one of the Die Hard movies from Bruce Willis. I love this line. He says, "Luggage, that punk pulled the Glock 7 on me." You know what that is? It's a porcelain gun made in Germany. It doesn't show up in airport X-ray machines, and it costs more than what you make in a month. Now, everything he just says is false, every word of it, right? There is no Glock 7. That model does not exist. It's not made out of porcelain. It's made out of metal with some plastic parts. It's not made in Germany. It's made in Austria. It will show up in an X-ray machine, and they're fairly affordable. But people watch movies and they get scared, and now we have legislation based on Die Hard. But the point is, makes sense, right? But the point is, none of this is new, right? There have been fears of plastic guns going back 30 years. Let me tell you something. Bullets are made out of metal, right? No matter how plastic your gun is, bullets are made out of metal, and they will trigger. You have like a quarter in your pocket, and you go through TSA, it finds your quarter, right? You're going to find a bullet. Maybe rubber bullets, I don't know. But bullets are made of metal. Okay. What about banning 3D printed guns? There was some effort in 2014 to prohibit 3D guns, but those bills are not going anywhere. I'll get to the current state maybe a little bit later. But maybe we can ban plastic, right? Maybe this is such a big threat, we just ban 3D printing altogether. Well, let me tell you something, folks. You can 3D print metal. This is a 1911 handgun. It was made in Austin, Texas. Fully functional, 1911 handgun, 3D printed. Now, this gun costs $40,000, right? No one in their right mind would spend 40 grand on a handgun. It's just insane. But you can do it. You can do it. Okay, so then how do they come after my guy, right? How do they come after my client? They used export control laws. Now, you probably never heard of export control laws. I didn't when I was in law school. Maybe you have. Maybe you're more advanced. But there's a set of rules called ITAR, the International Traffic in Arms Regulation. Josh, what on earth is ITAR? This is an elaborate series of rules to prevent Americans from shipping dangerous stuff abroad. I'll give you an easy example. Let's say I want to send Stinger missiles to Afghanistan. Okay, I probably should get the government's permission first. I think everyone agrees that's a good idea. Yeah, right. If I want to send Stinger missiles to Afghanistan, when they go back to Camp David, you put some missiles in their their bag on the way back home, right? Probably need the government's permission. But what about, I don't know, the blueprints for a nuclear submarine, right? If I want to send the blueprints of a nuclear submarine to, I don't know, China, right? I should probably get the government's permission first before I send the blueprints to our nuclear submarines to China. I think everyone agrees it's a good idea. Okay. But what happens when we move beyond classified information and actual, bombs, things that blow up? What happens if I make a cryptography algorithm, right? An algorithm, a code that can help secure my data. And that code may be very strong, and maybe the government will be able to crack it. Can the government say, no, you can't send code overseas because that might impact national security? Okay, now you're getting into a murky area. And in the 90s, the courts seemed to suggest, there were a lot of opinions on this, that you can't prohibit the shipment of code because the code is expressive, even if it's encryption. Everyone with me? Okay. Fast forward to 2013. Defense Distributed and Cody Wilson put online the files used to 3D print the Liberator. The Obama State Department sent a letter ordering them to remove from the internet the files used to make the pistol. It says these files should be removed from public access immediately. This was the first time the government ever used these export control regulations to shut down domestic speech that wasn't classified or private in any way. It was public speech in every regard. This letter triggered what's now 6 years of litigation. You'll find this when you're a lawyer. Things take forever, right? You see these things like, oh, Supreme Court, nationwide injunction today, Supreme Court decision 3 months later. No. Most litigation takes forever. It takes forever. This has been going on 6 years. The government said take down the files. Cody Wilson took down the files. Then in 2015, we sued the federal government. Yes, I sued the State Department for him. Myself and 2 other lawyers. We argue that it violates the First Amendment, Second Amendment, due process, and some other stuff as well. The district court ruled against us. Court of Appeals, divided opinion, ruled against us. The en banc court narrowly ruled against us. Supreme Court denied review. Then things got fun. The case was then remanded back to the district court for summary judgment proceedings. And the court said, I want you to consider settlement talk. And we actually were able to reach a settlement with the government, which we weren't surprised by, actually. The government had been slowly recognizing this was a very bad idea, and they've been moving these sort of controls on speech out of their realm. And they offered to settle the case with us. That's when things got fun. We announced the settlement. And the settlement was supposed to go into effect on a Friday. The dates don't matter, which was supposed to go into effect on a Friday. On Tuesday, we get this urgent letter from these various gun control groups. The Brady Campaign, Every Town for Gun Violence, Giffords. They keep changing the names. I don't remember what. Now it's just Giffords. It's not Giffords, it's just Giffords. And they say, we want to intervene to block your settlement. I'm like, what? So they seek a temporary restraining order, which is an urgent emergency proceeding, TRO, right? In district court in Austin. So on basically 1 day's notice, I have to go down to Austin and argue this TRO. And actually, I won that case. So I was able to defeat it, right? Good. Go Josh, right? I lose eventually, so I'll chalk my victories up while I can. We get the settlement. And that night, we put all the files online. We didn't tell anyone. Cody had planned to put the files online a week later, built some marketing. But the second we got this settlement and we got our license, I said, Cody, post now. And they were all online that evening. Then we recognized, OK, things can get really dicey. So that weekend, I started preparing a lawsuit. We're going to sue the Attorney General of New Jersey because he'd been threatening us. So start putting things in line. On Sunday, right before we filed, we get this frantic email from the Pennsylvania Attorney General. He was seeking a TRO against us in Pennsylvania federal court to block us from putting the files online. Now, wait a minute. I told him, I said, the files are online already. I didn't call him an idiot. I was like, the files are online. What are you doing? He's like, well, I don't believe you. And I sent him a link. He's like, well, we're still seeking the TRO. So on a Sunday afternoon, the court holds a hearing. You guys will be lawyers soon. When a judge says hearing, you say, yes, Your Honor. That's the answer. So on a Sunday afternoon, I had a hearing. Where was I? I was at LaGuardia Airport in New York City, in the lounge, taking the TRO hearing. Wherever you are, you do the call. And I told the judge, this case is insane. There's no notice. The files are online. And the judge said, OK, this case is crazy, right? So I told the judge, Judge, look, here's what we'll do. We will block all Pennsylvania IP addresses. That way Pennsylvania people can't access the website. And the judge says, OK, on that grounds, I will deny the TRO. OK, so 2 for 2. So far, Josh batting 1,000, right? Great. Next day, we're sued again by New Jersey. This time, they sue us in Chancery Court. Yes, Chancery Court. That's a thing in New Jersey. This is where you go if like your neighbor's making a lot of noise and you want like an injunction for nuisance, right? The New Jersey Attorney General, I swear to God, sought a nationwide injunction in Chancery Court against a Texas corporation to block internet postings that were already there. It was insane. So I'd spend up all night preparing this New Jersey pleadings. New Jersey doesn't do electronic. Everything's on paper. I had a curry and all this other stuff. And I argued this one, and I told the judge, look, Judge, we will block New Jersey IP addresses. Please don't give us a nationwide injunction because it'll shut down the website. Global injunction, my goodness, right? Josh wins. Okay, so 3 for 3 so far, right? 3 TROs in 4 days. Okay, the last one that didn't go my way. The last one was not a victory. The Washington Attorney General sued us in Seattle. He also sued the State Department, and he tried to block the settlement. He was joined by ultimately 20 other state attorneys general, right? Basically, the entire Democratic Attorney General Association was on my case. In fact, we were being sued by Pennsylvania and New Jersey in 2 different courts simultaneously. Very creative from them, right? So I had to argue this one by phone because I can't magically be in 5 places at once. It's not possible. And I'm arguing this case. And I'm talking judge, this is First Amendment. This is Pentagon Papers case, right? This is freedom of speech. And the judge asked me one question. What was the question he asked me? Mr. Blackman, do you represent all the parties? Now, why did he ask me this question? To make sure his injunction would stick. That way everyone had noticed and was served properly. I said, yes, Your Honor. Okay. At the end of the hearing, the judge says, I've heard all the arguments. I'm going to enter in a nationwide injunction to block the settlement. At which point I pipe up, and again, I'm on the phone, and I say, Judge, let me just be clear. Are you ordering my client to take down the files? And he's like, no, I'm not ordering him to do anything. But I said, Judge, by virtue of blocking the settlement, you are suspending the license he has, which allows him to post it. And then the judge made a quip. He said, well, your client's an anarchist, and sometimes they break the law. I'm paraphrasing. And I don't do what I did. I said, Your Honor, with respect, my client follows all court orders. And he said, well, Mr. Blackman, was attempting humor. Yeah, don't do what I did. I have tenure, so I don't care. But yeah, don't mouth off to judges. But he was embarrassed, and rightfully so. At that point, we now had an injunction blocking our settlement. I had won 3 TROs. I lost the 4th. I then had to call my client and tell him, Cody, we lost. And that's a tough call. I mean, you'll have that one day. Whatever courts you're going to have to tell your client, we didn't win, we lost. And that's a hard phone call to make, especially after this 5-day roller coaster. I'd built 90 hours in those 5 days. It's just been nonstop. And he took down the site. It took him a while. We have all these redundancies and firewalls. We took down the site. But we consider it a moral victory. These files were online for nearly 3 days. Right? They were online. They're everywhere. You can find them. If you Google them, you will find them, my friends. If I tell you how, I'll probably be indicted somewhere. But if you Google, you can find them. They're available online. And we consider this a huge moral victory. We won, in the short term at least. Now, where's the case? Oy vey. We are now in 4 separate courts. We're still appealing to the 3rd, the 5th, the 9th circuits simultaneously. So eventually, this case will come to some conclusion. I don't know quite when or where. Hopefully, the Supreme Court might want to consider this one's a good case, I think. We might have to get a split below. But this is a fascinating legal issue, a fascinating question of constitutional law, and something which I've had the honor and privilege of working on for the last almost 5 years of my life, and hopefully will come to a conclusion sometime soon. That's all I have. I'll turn it over to Professor Martins in a minute, but thank you so much for your attention. Do you want me to sit down when he comes up? Okay, great. That's fine.
So next we're going to have Professor Martin speak. He's a professor here at Liberty. Most all of you have had him as your law student. He really needs no introduction, but he's teaching our foundations class, clinical constitutional clinic, and has worked with the ADF. So he's very passionate about free speech and has some good stuff to say about this. So thank you.
All right. Professor Blackman, thank you so much for coming to. Thank you for coming here, Professor Blackman, and sharing with us here, the students, faculty, and staff. We really appreciate it. Sharing on a very important topic. And for those of you who are here who are maybe hoping for fireworks, right? We like to have, oh man, Professor Martin's going to come up and pow, 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 we're going to see the fire, and then, Professor Blackman's going to come back up and rebut, and you might be somewhat disappointed, okay? Because largely I have many points of agreement with Professor Blackman's presentation. Let me start on those. And the points of agreement, we may have some agreement for different reasons, but I'll start on those points of agreement, and then I'll talk about some points maybe as I like Professor Blackman, have litigated in the First Amendment area as well. I'm not just an academic. Before I came to Liberty University, I worked for the Alliance Defending Freedom and the National Legal Foundation, so I, like him, had the privilege to actually litigate in the federal courts on matters that impacted constitutional liberty. So I'm going to bring both of those perspectives to the table, hopefully. Let me start primarily with the area of how important these rights are. I think this is a very timely article and raises issues that are extremely important. Starting off with the freedom of speech and the right to bear arms, not only are these rights that are secured in our Constitution, but as you learn in foundations, you wouldn't be shocked. I think these are rights that are also secured by the laws of nature and the laws of nature's God. The freedom of speech is one of those inalienable rights that I would say Jefferson was referring to in the Declaration of Independence. And it's for this reason. Only God has the authority to judge us for our opinions or our thoughts. Repeatedly, you see in the scriptures, I'll give you one here, Jeremiah 17:10. God says, I, the Lord, search the heart and I test the mind. God is claiming exclusive jurisdiction or exclusive authority over the mind. So the thoughts I have, the ideas I have, the opinions I express, the government doesn't have authority to punish me for those thoughts, ideas, and opinions, generally speaking. Right? There are limitations. If I hire a hitman and say, go kill Professor so-and-so, I can't say, well, that was just my idea. The government can't punish me. Obviously, there's limits to this, but I'm giving you broad strokes here, right? So the laws of nature protect the right to express opinions because that's an area over which only God has jurisdiction. As well, the right to bear arms is also a law of nature right. You see this in Luke 22:36, right out of the mouth of Jesus. He tells his apostles to go purchase a sword. He says, hey guys, if you don't have a sword, make sure you go buy one. I think he wouldn't say that if he didn't presume that that was something that they had the ability to do. He, as the highest authority, was telling his apostles, you have the authority to go do this. You also see this in the Old Testament. This is one thing that can be a little fine-tuned here. Sometimes in the Bible, we expect God to always speak in terms of thou shalt and thou shalt not. And sometimes he does that, but sometimes he also will speak in a manner, he'll just show you some history and you'll go, ooh, that didn't work out well for those people. I wonder if I can learn a lesson from them. And this is one of the ways he speaks with respect to arms in 1 Samuel 13. You see, the Philistines they restricted the ability of any blacksmith to work in Israel. So there was no one in Israel who could make a sword or a spear or a shield. No one. And thus, what do you think the Philistines did anytime they wanted to rough up the nation of Israel? They kind of did so at their pleasure. In fact, if anyone in Israel wanted to actually sharpen their mattocks or a reaper or anything that had metal on it, they had to go to the Philistines to get it done. And there was only 2 swords in all the nation of Israel. And you see this constant presence of the Philistines. They're able to oppress Israel because they don't have any weapons. But for the intervention of God, the Philistines could have probably wiped out the Hebrews. But God has a knack for showing up on Israel's behalf when they need him. So again, these rights that we're dealing with today, the First and the Second Amendment, are extraordinarily important. I think the professor's comments are also very timely. You see with the prosecution of defense or the State Department going after Defense Distributed, I also read that last year the Senate Democrats tried to introduce a bill outlawing publication of 3D printer gun designs online. It didn't get anywhere, but they're going to try. And if they have a chance to win this next election, if they can secure a Democrat president and they can secure a majority in the Senate, I'll bet you they'll try again. I think you would agree with me on that. So it's very timely, very, very important. As far as the analysis, I largely agree with the analysis. I'm going to focus on the First Amendment because that's kind of my area. I largely agree with his analysis. The data that, first of all, that data should be protected under current First Amendment jurisprudence. Data contains information. It contains speech. I think that's pretty logical. I like the citation in your law review article. By the way, Tennessee Law Review. I was on that law review. Whoop, whoop. The citation of Brown versus entertainment merchants. The Supreme Court held that the information that goes into making video games that you put on your computers, they said, hey, that's protected by the First Amendment. They actually didn't even spend a lot of time on it. They're like, this is pretty straightforward. Why wouldn't this be protected? So I think that's very analogous to these 3D CAD plans for making weapons. Is it the exact same thing? No, but it's pretty darn close. I also agree with his analysis that any sort of ban on posting these plans, these 3D CAD plans online, I think those are content-based restrictions. Right? If any of you are in my First Amendment law seminar, or someday you will, if you're in it, I notice some of you here, and if someday you want to take it, the Supreme Court tells us when a regulation is content-based. It's content-based when enforcement authorities need to examine the content of the message that is conveyed in order to determine whether a violation has occurred. So how does the federal government determine whether or not Cody Wilson has violated a ban on posting internet 3D images of guns that can be printed with a 3D printer? They go online and they look. And if they see the content there, if they see the plans there, and they go, you violated the law, then we know that's a content-based regulation. Okay? And content-based regulations get the highest level of judicial scrutiny that the courts can apply. What that means is, one thing you all are going to learn if you haven't learned already, particularly one else, no one goes into court, it's not a 50-50 fight. Whenever you go into court, someone is presumed to win. If you're in a civil court and you're the civil plaintiff, you're presumed to win. You've got to overcome a burden of proof that says, usually like 51%. It's more probable than not that I win. If you're planning on being a prosecutor someday, you're in a worse situation. You go into court with beyond a reasonable doubt. It's not 50-50. Can I kind of just edge out the other guy? It's not like a football game where if you win by 1 point, you win. You've got this burden. Well, in First Amendment cases, the court has said if the government engages in content-based regulations, they are regulating based on the content of what you're speaking, we put this extraordinarily high burden on the government. And if the government can't meet that burden, they lose. So again, it's not like baseball, tie goes to the runner. It's a really high burden. And Professor Blackman, I think, nailed that. And I think he's also correct that when you have these content-based restrictions, all of them are supposed to be subject to this strict scrutiny. And what exactly is that burden? Well, the court says the government needs to prove to the court that their law is narrowly tailored to further a compelling governmental interest. So, narrow tailoring. That means it needs to be the least restrictive means, the means that is least restrictive on freedom of speech and freedom of expression. And a compelling governmental interest means it's got to be an interest of the highest order. So these are really, 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 really high orders. Okay, not somewhat important or, I could flip a coin on this. It's governmental interests of the highest order. So you can see this is a very, very difficult burden for the government to satisfy. And I agree with all elements of that analysis. I think this is where I would say, from a litigator's perspective, I would say, what's probably the best way to present this? Maybe like devil's advocate. If I was trying to shore up my case and go, where are the points where I think the other side might try to get me in my heel? Where might be the weak places where I could be challenged? And this is where I think I'd present. So I don't know if I'd express this directly as disagreements, but more as, you know what, these are the areas of my case that I'm going to really watch out for because I think the other side's going to hone in right on these places. I think the article makes this comparison to these gun plans, these 3D CAD gun plans, as it makes an analogy to pictures. I say this is similar to pictures of guns. And while I think principally that may be the case, we know, and we all know this, judges are human beings. And even though the law may say something, and even in principle it may say the law may say something, judges are human beings, and they go, yeah, well, there's a difference between a picture of a gun and a picture of a gun that comes with plans that tells you how to make that gun. I think judges are going to not simply say, well, this looks like a picture, so I'm just going to treat it like any old picture of a gun. I think they're going to look at this a little closer. Also, as you saw in your own case, unfortunately, some of these courts are not going to treat this as a content-based regulation. They're going to say these are content neutral, and the government actually isn't after suppressing ideas. They're actually after something else. In fact, I think that's what you faced at the district court in the Fifth Circuit. They said, oh, this is content neutral, so we can just use intermediate scrutiny. So instead of this really, really high burden for the government, they just have to jump over a lighter burden. And the Fifth Circuit, by and large, affirmed those grounds. So I think that there's that running up against that risk that some courts might say this is content neutral. We've got to do a lower level of scrutiny. I think there's another risk here. Even if you have a court which does it properly, as I think Professor and I would agree, that these are content-based regulations that should be subject to strict scrutiny, I still think there may be some courts that might say, in this circumstance, strict scrutiny is met. And the one case that this is, again, me just thinking along the lines, the interest that I'm thinking about here is national security and national defense. The courts have said over and over again, when you're dealing with national security and national defense, these are compelling governmental interests. And if I was the other side, like if I was the government and I was trying to defend my lawsuit defend against Professor Blackman's lawsuit, I would pull up the Holder versus Humanitarian Law Project case, which he's familiar with. He cited to in his law review article. I'm not telling it. This is not a surprise to him. But that would probably be the one that I'd bring up and say, okay, look, Your Honor, in the Holder case, the Supreme Court upheld a law that prohibited the provision of teaching and training to foreign terrorist groups, even though it was for the purpose of furthering their lawful objectives. So these groups were saying, hey, look, Congress has just banned us from providing any sort of provision, any sort of assistance whatsoever to some groups that have been labeled terror groups. We're not trying to help their terror activities. We're actually trying to help their lawful political objectives. And Congress has said we can't do that. We can't provide them with any sort of material aid. And these groups are saying, well, we get that in terms of we can't give them nuclear bombs, but what about just simply training and teaching, providing information? Surely that's protected under the First Amendment. And surely if it's used for lawful objectives, such as peaceful political advocacy, then this falls squarely within the First Amendment. Right, U.S. Supreme Court? Wrong, said the U.S. Supreme Court. They said, no, look, the federal government has, even though this is teaching and training, and even though that might normally implicate these First Amendment concerns, we say, look, it does implicate First Amendment concerns, but here the government has passed that very strict test. Okay, the government can claim that it has a compelling governmental interest, national security, national defense, relations with its allies around the globe. These are compelling governmental interests. And I think this has some applications to the ITAR, the Department of State applying ITAR to your client. They were saying, look, I know you may just, Cody, you may just want to create this gun for good, lawful Americans to be able to protect themselves. The problem is terrorists can get a hold of these guns, and then they can come into our airports, and they can come into various high security places, can't be detected, and they can get off that one shot that they need to take out a public official, the president, whoever it may be. And so I think there's some analogies there. And I think what we would see here is really the fight is on the narrow tailoring prong. I think that's where it's going to be. If I'm the government, I'm saying to Professor Blackman, hey, look, there is no way we can keep this information out of the hands of terrorists other than blocking it on the internet. We've got to block the plans. If we don't, that's the only way we can do it. All right? Professor Blackman's probably pushed back and say, Your Honor, but we've had plans out there in books. You can go to Amazon and get a large portion of these plans, on various books and other ways. There's other ways that terrorists could get this same material. And so what would happen here is how narrowly Congress or the states drafted these laws is really where the fight's going to be. It's where it's going to end up at the end of the day. I have probably the part of the presentation that I maybe have I would say most doubt in, because again, I'm pretty much lock, stop and barrel with no pun intended with Professor Blackman on the points he's making here. However, the hybrid rights claim, that has an intellectual appeal to me, but what I've seen in the courts actually applying the hybrid rights exception that the court raised in Employment Division versus Smith, I've not seen a lot of success. So I don't know if it's that I'm concerned that I don't see the courts adopting this. Well, actually, let me go into detail. So in Employment Division versus Smith, the Supreme Court said to this group of gentlemen who were basically fired because they were smoking peyote. And they said, this is part of our free exercise of religion. And they're fired. They tried to get unemployment benefits. The state said, no, you can't get that because that was misconduct. And they said, oh no, we were simply following our Indian religious beliefs, and this is our free exercise of religion, so we're going to sue you. Went up to the U.S. Supreme Court. Long and short of it, the Supreme Court said, look, if you raise a free exercise claim to a neutral and generally applicable law, we're not going to apply that really, really high standard to the government. We're actually going to apply a really, really low standard. And the plaintiff said, well, if that's the case, what about all these old cases in the past where you did seem to apply a really high standard to free exercise cases? And the court said, yeah, well, what happened in those cases was actually it was a hybrid. In those cases, the plaintiffs brought a free exercise claim and a free speech claim or a freedom of association claim, something along those lines. And that's why we took this really low level of scrutiny and we bumped it way up and made it really hard for the government. Well, the Supreme Court, so there's the hybrid rights theory. And the Supreme Court said to these peyote guys, hey, get out of here. If you ever want strict scrutiny again, you got to bring in some other claim. Well, this started to filter in through the circuits, and basically only 2 circuits that I can find have adopted that hybrid theory, and several others have rejected it, either on principle grounds or just said it's unworkable. And I haven't found a case where the Supreme Court has applied it again. They'll pay lip service to it in some cases, but I haven't seen where they've actually applied it in a manner that it would make a difference. And I think the reason is it is kind of hard to see logically. I'd like to see the court clarify how this would work out. So think about it this way. If the court said, look, you come into court and you challenge a law under the free exercise clause, normally, after Smith, you're going to get this low level of scrutiny. Okay? But if you bring in some other claim on top of it, some other constitutional claim, we bump it up to this high level of scrutiny. Well, the problem with that is, what if that other, let's say this other claim comes in, you just tag on any weak claim. So I've got a free exercise claim, and then I tag on some other weak tangentially related claim. Does 1 weak claim plus another weak claim equal a very strong strict scrutiny claim? And some of the circuits have said that's one of the reasons why we're concerned, because you'd actually swallow up the rule in Smith. If the government generally can pass neutral laws of general applicability without violating the free exercise clause, then why would adding some other weak claim to it suddenly jack it up to strict scrutiny? The flip side to that is, well, if I have to, what if we don't bring in a weak claim? What if we bring in a separate strong claim? Well, then why do I need the free exercise clause at all? Okay? If I'm challenging some activity that the government is engaged in, they're regulating my conduct, and I think it violates one clause of the Constitution weakly, but another one really strongly, the court says, well, why do we even need this weak claim anymore? You can prevail on the strong claim. And it seems like that's the head scratcher that's kind of keeping the circuits from adopting this hybrid form. And in fact, not only that, I've actually seen the Supreme Court, unfortunately, do the opposite. In the case of CLS, Christian Legal Society versus Martinez, students brought actually free speech challenge, freedom of association, and free exercise clause. They brought 3 together. This would have been a perfect hybrid rights opportunity. We got the free exercise clause, the free speech clause, and the freedom of association, Your Honor. And just the facts of this case, essentially it was a Christian group at University of California, Hastings Law School that was de-recognized by the university. The university said, in order for you to be a student group on campus, you have to sign off on our non-discrimination policy, which says you can't discriminate based on race, religion, sex, sexual orientation, etc. And the organization said, well, we actually can't have someone be the president of Christian Legal Society if they're going to violate tenets of how to live a moral Christian life. So we can't have we wouldn't have a rapist as the president of Christian Legal Society. We wouldn't have a philanderer be the president of Christian Legal Society, and we wouldn't have someone engaged in a same-sex relationship as a member of the Christian Legal Society, because all of those behaviors violate biblical, what the Bible says about living a moral life, and our leaders have to live a moral Christian life. Well, the Supreme Court said, instead, you would hope the Supreme Court would say, wow, 3 claims, all from the First Amendment, all brought together. Hastings, you lose, right? No, the court actually separated the claims and said, your free exercise clause claim is weak. They punted it in a sentence. And they said, and your other two claims, the freedom of association and the free speech clause, we're going to look at the one that's the weakest. Or we're going to look at the one, let's put it this way, we're going to look at the one that is the most government, that is the lowest hurdle for the government to jump over, and that's the one we're going to apply. So instead of combining them to give us sort of like a super scrutiny, the court actually did the opposite and said, which one's the weakest in this context? And that's the one we're going to apply. So while I do, from a plaintiff's perspective, Professor Blackman, I sympathize with that argument. In fact, I've tried to make that argument before, this hybrid rights claim, and it just doesn't seem like the courts want to bite on that argument. So long and short, those are my thoughts. Again, Professor Blackman, I sincerely appreciate you coming and presenting with us today, and it was extremely informative.
There's so much there, I don't know where to begin. I also know we have students who've been sitting here patiently. So how about I go to questions, and maybe I'll try to work in some of the response to Martin's based on what you all asked. So please, questions. In your mind. Was there nothing there? Yeah, right there.
I have a whole bunch of questions, but I think the one that I think most of us in the group is, you talked a little bit about the IP aspect that you mentioned in large students not in conversation yet. Several websites have viewed this information as copyrighted.
Yeah.
Could you just elaborate on that a little bit more?
Right. So you may have taken IP, or maybe you'll take it later in law school. Generally, the designs to make an item can be copyrighted. So, for example, Glock, right? The design of their handgun is copyrighted. I can't just go and knock off and make an exact replica of the handgun. The files that Cody are dealing with are open source. That is, he's relinquished any claim to copyright. He's not claiming that they're protected. So therefore, they can be copied at will. Where IP does play a factor in intellectual property is with respect to counterfeit goods, right? If I want to 3D print a pair of LeBron James sneakers, right? That might be a $300 pair of sneakers I can print for $5 of parts. Nike and the fashion manufacturers are petrified of 3D printers because it will allow people to easily knock off their goods. So I think at some point we will see legislation on 3D printing, not about guns, but about IP property, right? To prevent people from knocking off materials. And if they can regulate counterfeiting goods, that might sweep in gun regulation. So that's about as far as I'll go for now. But IP does play an important role in this area. Other questions? Please.
Do you see states getting involved in this at all? It's one that we've been talking
Unfortunately.
Talking so much about the federal angle, and I know now the states are obviously on your tail. But I guess I'm just trying to think. How do you think this is going to differ with the Fed versus the states? I mean, one thought I had was, I don't know if you have that national security interest anymore. The federal, when you're litigating against the federal government, they could raise national security, international relations. Yeah. And I'm not sure those are open to the state. So what is, because I'm asking a bunch of questions, what is the state's angle, given that I'm not sure they have the national security, national foreign relations?
Well, we're like fighting a two-front war. We are simultaneously suing the federal government and being sued by the state government. So we're like suing both at the same time. The states have a much tougher road for a couple reasons. One is what's called preemption. There's a federal law called the Communications Decency Act. You may have heard of it. Enacted in the mid-1990s. And Section 230 of this law says that states cannot impose liability on internet sites. And I'm oversimplifying grossly. But for example, it will prevent a state from punishing an internet site that hosts some, objectionable material, maybe something that violates a copyright or defamatory, right? You can punish the person who creates the content, but not the service that hosts it, right? This was to ensure that places like America Online and online message boards would be published. We've argued in court that the states are punishing us for hosting these files. That's preempted by Section 230. Section 230 would not prohibit creation, so our suit quite deliberately involves both. We both create and host other content. So you still need the First Amendment there. Now, in terms of the state's interest, they don't have national security, but they say we need to protect our people, right? We don't have these guns in our street, these plastic guns. And look, these judges were very acceptable. New Jersey courts, I didn't even mention what the New Jersey argument was. New Jersey argued that's a common law nuisance to put a file on the internet. They wanted, I didn't even mention this, it's laughable. They wanted a nationwide injunction to bar us from putting files on the internet because posting files online is a nuisance. Now, you may think, Josh, this is insane. New Jersey courts actually held that guns are nuisances, that the illegal sale of guns in a jurisdiction is a nuisance, and they allowed a tort suit against a manufacturer in a nuisance theory. Now, nuisance law is nuts, right? Nuisance means whatever a judge wants it to mean. No, it's not like your neighbor's making noise or smoke. Or guns were nuisances. So the judge said, well, if a gun's a nuisance and a file used to make a gun was a nuisance, and I'm tearing my hair out when I'm listening. Like, no, judge, that's not right. But when a judge says something, you can't tell me he's wrong. You say, I'm going to appeal. There's no appeal to be had. So the short answer is I think the states are a much shakier ground. I actually told the judge in Austin that I think the federal government has a better interest. They don't have enough, but I actually admitted I think the feds have a much stronger interest than the states, and I admitted that in court. But I think neither is narrowly tailored enough to address your other point. Okay, other questions? Yes, sir.
Does this now apply to, let's say, people home making their own? It's not used as a weapon, but it's like a couple of YouTube channels make powerful lasers, especially in the infrared.
What are you looking at?
Well, you can make a powerful infrared laser that's in the watt range. It's like, let's say.
I don't know what that is, but it sounds dangerous.
Yeah, it can burn something like 100 meters away or 50 meters.
So a death ray of some sort?
Yeah.
Oh boy. Well, first time I've had that question. Look, again, if you're actually making the death ray, the state probably has an interest in stopping you. But merely sharing the information of how to make the death ray, I think, is more problematic. Now, in this case, our case is helped by the fact that making this gun is fully lawful under federal law. Right? You can make this handgun fine. State law, it's not. The states have, New Jersey and California, have imposed these regulations that basically make it a crime to make your own handgun, even if you're not selling it. California has a regime where you have to get approved, and they're not going to approve it. And New Jersey makes you get these really expensive manufacturing licenses, which you're not going to get. So in both states, it's basically de facto illegal to make your own handgun. It's just not feasible. But thank you for the question. I don't know about these powerful death rays. That sounds scary. But is it scary?
No.
No? Oh, okay. If you say so.
It's visible and it can put things far away.
Wait, are these like the blasters like from Star Wars? Like,
No,
you know?
that's too much impulse. You're talking thousands of watts.
Yeah, we need more watts.
No driver can support that.
No, okay, not yet. Okay, we'll keep working. All right, other questions? Yes, sir.
The principles that you apply to this case, would you carry those over to the Julian Assange situation about freedom of information?
Oh yeah, that's a good question. So if you couldn't hear, it was a question about the Julian Assange, the WikiLeaks case. If you notice, I kept saying unclassified. If you notice, I kept saying the word unclassified. The courts have created this entire body of case law about classified information, right? It's not well developed. I don't know why classified speech receives zero protection. Indeed, reporters routinely publish classified information. Routinely, go open up any newspaper on a daily basis. Why is WikiLeaks treated differently than a newspaper? And I think there's a prosecution now of Assange. He was indicted. He's going to raise the First Amendment as a defense. I don't know that he's wrong. I think it's dangerous when you start treating Assange different than a newspaper. I mean, the guy is a creep, to be sure, but I'm not sure what he did is all that different than the New York Times did. The Pentagon Papers case from 4 decades ago, they publish all these classified materials. I think your hand was up too?
Yeah, I teach the North Carolina concealed carry course, and I get this question a lot. The North Carolina statute defines a handgun as a short handle, made to be carried with one hand. That's as far as it goes. I get the question a lot of, given that obviously you print a gun for your own personal use as long as you don't sell it. Has it been tested or even discussed whether that gun can be used to conceal carry? That's a routine question I see.
Oh, could you conceal? I mean, it's small. It could definitely fit in a holster on your side. It's a single shot pistol. I mean, it's basically the equivalent of an old school musket from the 1700s. Right. I think to carry it outside the home, you wouldn't need a CHL.
Yeah. I get the question a lot, and I've had a couple of police officers before. They have instructed to confiscate 3D guns if they come across them.
Well, across them in the home, or if they're being transported.
Someone is carrying it as a concealed.
Oh, you're saying that it's not covered by the statute?
That's what I'm at. I don't know if it is covered by the statute. It doesn't define a gun any other way than that short handle that may be carried with one hand.
I think that sounds like it. You can carry it with one hand. I mean, it's small. I think it's covered. Okay. Thank you. Anyone else wants to ask a question yet? All right, last question.
You talked about ITAR. I agree with you. It's a pretty terrible way to try to regulate this. I'm sure you see at some point, the government does have an interest in regulating it to an extent. What do you think the future of this is going to look like as far as the next Cody Wilson that comes up?
Well, look, the government for years has recognized that ITAR is not a good scheme to regulate technical data, this sort of information. They've recognized this for years. And what they've done, what they've tried to do, the court stopped them, but what the government tried to do was to move control of these devices from the State Department to the Commerce Department. The upshot of the Commerce Department, they don't require a approval process. You basically pay you pay a fee and you can export these files, right? Whereas with the State Department, you need a license. And I think that's a much better way. As long as the government knows who you are and they can track you, I don't think it's the end of the world, but the pre-approval process that the ITAR requires now, I think is constitutionally suspect.
All right.
I think that's our time.
Yep, that wrapped up our event. Thank you all for coming.
Thank you all so